if mandatory. Then also may come to last paragraph. A posted appointment shall be subject to the final order to be made by the Honorable High Court at petition such and such, filed in Honorable High Court such and such. Last date. Fully filled up application received through registered post such and such be accepted in the office undersigned by such and such date. No application shall be accepted after the date scheduled. Now Lordship may have. Now Lordship may have the affidavit of the secretary in page 284 to 291. This was before the High Court. Not a word on whisper on that. Lordship is completed.
The persons who are holding 2 years diploma.
Yes, 2 years degree.
Or they are D.ed holders.
D.ed.
They have been held to be ineligible.
No, that would
they are D.ed holders.
both prospective as 70%.
Petitioners were also B.ed holders.
No. We are diploma holders.
They are, no, not my holders.
With that NIOS
This scheme. Under scheme.
Program, no diploma.
NIOS.
They are concerned, they are B.ed.
Lordship, if they could show the diploma, I am out of the board. It's a program. Distance learning. No 2 years, 18 months. Lordship, I have this.
Degree of education is B.ed, na?
B.ed.
Are you having diploma in education? Are you having diploma in education?
Yes.
B.ed certificate.
Lordship may record it.
We have diploma, but the issue is this is given in 18 months because of the notification, not in 2 years. That's the only difference. So 18 months have been treated on par with 2 years.
How can it be treated as 18 months?
For the reason,
Let them complete.
No, you see, High Court says in para 3, the petitioners possess degree of education, that is B.ed.
Yes, that's me.
Your petition is
No, I'm not. That's wrong.
Your petition has been dismissed or allowed.
That petition is allowed, and that's why there's a challenge to it. I'm not.
Yes, therefore, these petitioners do not have B.ed.
No, they're not.
High Court says the petitioners possess degree of education.
we are not B.ed one. Or there is a restriction.
Is it right or wrong?
Wrong. Subject to because it's their petitions.
And they have cleared TET, Teacher Ability Test. They have also obtained diploma as recognized by the NCT in elementary education in ODL mode.
Yes, they are in-house diploma. They are in-house teacher. 18 months diploma. This 18 months includes 6 years training, which otherwise the 2-year diploma holders had to do. That is 2 years plus 6 months training. Vis-a-vis 18 months consolidated.
I'm only
NIOS. And there is a reason asking
whether the petitioners before the High Court,
They did not have the degree or diploma.
they did not have the degree or diploma, only 18 months ODL mode.
Program. It is especially called program. Now, Lordship, map page 287. This is the secretary's, the education secretary's affidavit before the High Court. At present, against the advertisement issued for the recruitment for the year 2018-19 and 2021, 70% selection process has been completed. However, the candidature of 21 candidates who are petitioner in the bunch of petition who are having 18 months d.el.ed from NIOS considered that situation, the regular d.el.ed training candidates who have already been selected on the which of which the merit decision prepared would have to be amended by the department. In this case, several anomalies would occur. High Court, without there being a challenge to the advertisement first, without asking for any amendment to be carried out, without asking for a press advertisement to be put in the paper. So on the date of the advertisement, the person not being qualified could not have applied. High Court says consider them. On what basis? Now Lordship may have the impugned judgment. It makes very interesting reading, Lordship. Let's have first the program, one-time program, page 18 to 20. What is it all about? Page 18 of the impugned judgment.
The scheme I only been sold for already in service. And there is no
page 18. So this is referring to the program introduced. Now, Lordship may skip the part. Lordship may come to page 20, bottom paragraph. This is what the program which my friends, this just Mr. Shukla before the court. These are the persons.
Yeah, because that specifically says that this program shall be only for those in service untrained teachers.
Yes, this is what they are.
So, are they in service or?
They are in service. They are in service persons.
But if they are in service, they are entitled to be protected.
No, they have not been ousted. They are seeking now selection through the advertisement for which they are not qualified. They say he does to be qualified for the fresh selection.
For the
fresh selection.
But if they are already in service,
how could they? That is what I want to tell to the court.
In fact, there are two categories of institutions: private management institutions and government institutions. So this
you are in service in
we are in service in an institution in question already working.
No, in private
or government. Private is private.
It is working an employment in government also.
Yes.
How can that be done?
No. No, it is a non-aided institution. This will be aided institution.
So this institution only in order to protect wherever you are protected.
Yes,
exactly.
That's
the aim is that wherever you are there, you are protected.
Yes.
But then you can't compete with otherwise there will be a competition between non-equals.
Yes.
But the fact of the matter is,
That is only will be complete quickly.
Lordship may turn to page 37, para 31 and 32. I'm taking the Lordship to the findings of the High Court. That's it.
Page 37.
Page 37, para 31, 32. The High Court is interpreting the way it wants it to be interpreted. On a plain reading, para 31. Of the above provision, it is clear that the preference to notification by the central government is not to the minimum qualification, but to the academic authority authorized by central government, which is empowered to lay down the minimum qualification to be eligible for the appointment teacher. This is a plain meaning of the section 27 of that. Lordship may read that. I will take Lordship to section 21. It is not even the respondent that the NCT is not authorized to academic authority under section 31 of the Act. The submission learned counsel for the question contrary to observation by the Supreme Court in Shiv Kumar Patak's case. The minimum qualification has to be laid down by the academic authority authorized by the central government and not by the central government itself. It is the academic authority which has to be authorized by the notification. Here there is no notification, and the High Court, I will take the court to the finding. No notification required. While holding it, the quoting from the Lordship judgment in Shiv Kumar Patak's case, it is required to be done by the notification. Lordship may note it. Now, in the next submission of the learned Deputy Advocate General that the recognition of such has not been published in the official gazette. This is very important. Notification. The recognition such and such is not. He submits that the NCT has already issued notification such as 23(1), which the High Court is running on in the earlier paragraph, laying down the minimum qualification and minimum qualification and teachers eligible to such and such. His submission is that if the minimum qualification have to be relaxed, the same can only be done through a notification published in Gazette. It is thus argued that the second not obliged to take cognizance of order, declaration order such and such, which is binding and enforceable. The notification prescribes the minimum qualification such and such. Learned 2 years. 2-year diploma in elementary education. Now, Lordship may please to turn to page 42. Page 42. Power to relax. This is most important. The one I read out to the court. This is a general power to relax, which is being taken note of in the notification which I read out to the court. It's a general power to relax on the recommendations of the central government or state government or union territory concerned or in cases for removal of any hardship caused in adhering to the provision of these regulations, keeping in view the circumstances peculiar to the said government territory, it shall be open to the chairperson for regions to be recorded in writing to relax any of the provisional regulations in respect to any class category institution in the concerned territory. Now, this is subject to that power to relax, which I read out to the court in page 132, which says it cannot be relaxed under any circumstances. Page 132.
No, but NCT regulation has been relaxed. In their own regulation, they have relaxed the requirement of eligibility.
There is a proviso. There is a proviso. Relaxation is there. There is a proviso. You can't relax for 1 to 5.
But they are in service.
Right.
virtue of that communication, those persons who were in service,
In government service,
either
they intend to continue.
if they were in government service, they are completed 18 months, they would continue in the government.
Yeah, they'll continue.
1 minute, please, sorry.
Okay, I'm sorry. Yes, I'm sorry.
There's no need to.
Yeah, I'm so actually sorry. I'm sorry.
They are already in service in private institutions.
No.
1 minute. If they are already in service in private institutions, they will continue to be there
Yes.
after completion of 18 months. But now they can't compete for the open.
Exactly. Your Lordship is there.
No, but the notification says this program shall be only for those in service untrained teachers in government aided / private unaided.
That is for the purpose of those who are already continuing for their selection in case there is no fresh recruitment. This is fresh recruitment in terms of our service rules. There, the relaxation does not apply. Our service rules continue to maintain 2 years plus 6 months of training. Now, without amending either your own notification or the NCT, by virtue of a letter, they say you take that. Now, that is not possible. Earlier, following that letter, we issued a notification.
I don't think, because the whole program is to train the untrained teachers under the RTE. The object is to train the untrained
So
teachers.
it's a therefore opposite.
The sweep is to cover all those government aided, unaided, private aided, unaided.
Absolutely right.
Their qualification of 18 months program has been recognized by way of this regulation.
So that
Once it is a recognized qualification under the RTE,
yes, so that they could continue in service and do not become ineligible because of the Right to Education Act.
They will continue.
Not they'll continue.
They will continue, but only in private.
No, whichever institution.
Then private will continue.
May I just respond? If we hear everybody at a time, will we be in a position to finish the matter?
Well, I'll just respond for a moment, just then my learning will continue. Well, your lordships will have to decide. One thing is clear, that those who are in service, whether in government or private, will remain in service if they do the
Wherever they are.
Yes,
will remain in service.
Right.
So the second question will arise, if they are in private institutions and they've got this qualification now, can they apply? That's the second issue, is whether they can apply. There's a distinction between fresh people applying and people in service somewhere applying. That lordships will have to consider that. So, Mulaj, the issue will be whether the rule that applies is for 2 years, or whether there has been a relaxation. Your lordship will have to consider that. Whether there's been a relaxation, that's all. Now the other,
Whether that relaxation is by a notification.
well, the relaxation is not by a
If
notification.
we hear everybody at a time, it will be difficult for us.
But page 178 is the complete answer. Lordship,
Your lordship will just keep this in mind. All this will be explained.
so Lordship, I read out to the court, this review order judgment itself says that in the Sripal Pathak's case, it is required to be notified. Now, what does the High Court say itself in page 48? Court is contradicting itself. Page 48 on top.
Page
48 top. I mean, this either way, whichever the lordships go, but this judgment has to go. It's saying something which is contrary to what he said earlier in paragraph. Now it says, that merely because the recognition order may not have been notified, it does not lose its force.
page
48 top, para 44. How can you say that? When you are quoting from the Pathak's case, it is required to be notified. You can't say that.
Yes, Mr. Sethi.
But I have formulated there are 6 propositions which I have formulated for your lordship.
Good.
In a sense, Lord, there are just 6 submissions which arise. The first one, Lord, page 1, your Lordship has. NCT seeks to enforce its executive order of 6th of January, prescribing a qualification different from that as statutorily notified by it earlier on 23rd of August 2010. Now, both this 23rd August 2010 is a statutory notification under
Issued under the provisions of the Act.
This Lord has amended on 27th of July 2011.
2010 as well as 2014, I think.
Correct. Again under section 23 and 2G of the RTA. Now the state government has framed and notified service regulations 2012 in conformity with this prescribed statutory qualification notified by the NCT. An unnotified executive instruction 6th of January 2021 cannot amend or override a statutory regulation notified under section 23 and 2G. This is the first proposition. The second one is, Lord, no one has challenged the advertisement of 29th of December 2020 and prescribed qualifications therein as eligibility for appointment, nor the service rules under which the advertisement was published. The writ petitioners have only sought a mandamus to permit them to be considered for appointment, divorce the stipulations.
मान लो तकड़ी बहस चल रही है आज तो भाई कोर्ट में। आज हो जाएगा, देखा फाइनल लग रहा है।
Sought a mandamus to permit them to be considered for appointment, divorce the stipulations in the advertisement. As long as the prescribed eligibility in the advertisement and the regulations stand, a contrary eligibility cannot be applied and none of the writ petitioners can be considered.
खड़ा भी नहीं हो रहा है।
The third one, Lord,
खड़ा भी नहीं होने
after issue of the advertisement and once selection process is set into motion, essential stipulations and rules governing the recruitment cannot be changed midway. The state was right in withdrawing the GO. Earlier we allowed it not on the basis of the letter, but then we realized that this is contrary to our service regulations, so we withdrew that.
हाँ करेंगे।
As the service rules framed in accordance with the NCT regulations framed in section 23 had no provision for 18 months diploma. A change in the goalpost midway during the selection process would negate and destroy the recruitment already made as per existing and prescribed service rules of 2012 as amended. Fourth submission, Lord, the NCT prescribes 18 months diploma in elementary education by NIOS through ODL mode as the minimum qualification by its executive order of 6th of January. It cannot prohibit 24 months diploma in elementary education plus 6 months bridge course by regular mode prescribed by the state under the service rules. As in the opinion of the state, it is a better, more suitable qualification. If the state wants to hire better qualified teachers, it can always do so as part of state policy. The fifth, Lord, Judicial review can neither expand the ambit of the prescribed qualification nor decide the equivalence of prescribed qualifications. This your lordships have held in 2021. Equivalence of qualifications is a matter for the state as a recruiting authority to determine.
In any case,
Yes.
the national council can prescribe only the minimum.
Correct.
You can't go below the minimum.
Correct.
But you are always entitled to prescribe something more than minimum.
Quite right. That's exactly what your lord.
That
Even in Satyapal Reddy also.
that is settled right from
Yes.
Adhyanam.
Lordship, please. I'm grateful, Lord. Your lordship also had recently, my lord, in Devendra Bhaskar 2021 SC 11116. And the last submission, Lord, the impugned judgment insofar as it relies on judgment of the single judge of the Patna High Court dated 21st of January 2020 is erroneous